Hi, how are you?
Good. How are you?
I'm fantastic. Sorry I'm late.
Good. That's okay. I understand you had a trial the last couple of weeks.
I did, and it was very interesting running a very complicated, detailed, multi-witness, multi-issue, multi-jurisdictional trial all on a laptop.
Yeah, I can only imagine the logistics of it all, but it went okay.
It went brilliantly.
Yeah.
And so it's the idea that you could actually do so much off of a device is just shocking. But it went well, and I'll tell you, the trial started in February and ended in March, and the trial involved our topic of today, which is the changes to the Divorce Act and to the provincial legislation governing the subjects of parenting. And so when we started the trial, we were talking under the old legislation. By the end of the trial, we were talking about the new legislation, and it was quite interesting. So that's my segue to having you and I talk about the new law. But before I do, I just want to say I really miss our IG Live.
I did too. I missed chatting with you, and I missed everyone watching us. And I'm glad we're back because I really enjoy doing these with you every week.
For sure. So I printed out the table of contents for the new Divorce Act. But before we jump right into it, I sort of want to educate our viewers on what we're talking about, okay? And so in Canada, like in many Commonwealth countries, we have legislative law, which is basically the law found in books passed by our governments, whether the government is provincial or federal, and that's called statutes or legislation. Then we've got case law, which is decided by judges. So judges who hear cases day in and day out make rulings. Those rulings sometimes are written up in decisions, and those are the decisions that we as lawyers rely upon to give advice to people and for people to follow in terms of how they should conduct themselves. Some people call that common law, some people call it case law. In law school, we called it precedence. When a case makes a point, we call it stare decisis. Whatever you want to call it, legal proposition, axiom of law. Long, short, the law that we're going to talk about today is the change to the statutory law. There were two changes made that affect family law. One change was made to the federal law, and then the matching change was made to the provincial law. The federal law that deals with parenting is called the Divorce Act. The provincial law that deals with parenting in Ontario is called the Children's Law Reform Act. And all of that is really sort of immaterial for our call today, because the law is the same both provincially and federally, and what we're about to share with our viewers is indeed that. The other thing I want to mention before we jump in is that sometimes statutory law influences common law or case law. But this is a case where it's the exact opposite. What ended up happening was in jurisdictions all over the world, social scientists, judges, and lawyers were all saying, these words, custody, it's causing friction. People come to court and they're like, I want custody. No, I want custody. No, I can't have joint custody because I can't agree with you. You and I don't agree on anything, so we can't have joint anything. And so it's creating a whole bunch of conflict. And Justice Bonato, in a case that was before the Court of Appeal of about 10 years ago, she said, we got to move away from this. These words are really not helping families. Now, she wasn't the most brilliant. I mean, she is very bright, but she was really repeating what many other people were saying for many years. It finally got the ears of the legislatures, and they said, hey, you know what? Maybe we should change the law. And that is what happened on March 1, 2021, after years of consultations and years of discussions and bills and royal assent. We finally got this law, and for the next 5, 10, 20 years, people will still be using those words, custody and access. But once we kind of get through it, we will be on the other side of this, where those words will no longer be part of our lexicon. So let me ask you, Leanne, what do you think the psychological effect of getting rid of those words, custody and access, and introducing the word parenting is really going to have on your clients, but on society in general?
I think it's going to have a really positive psychological effect because, as you mentioned a few minutes ago, Steve, I mean, that's one of the dominant themes I find with most new clients who come in the door. They say to me, I want custody. And then when I probe them further as to what they actually even mean by that, usually they mean that they want the children to be with them, to be living with them more of the time, which in fact is not even what the old definition custody even referred to. The custody under the previous legislation, it referred to decision making. And so with the new changes, we have the proper terminology really, where we have decision making and parenting, which are different things because parenting time is separate from decision making. You can have sole decision making, but shared parenting, or, various versions of these things. And so I think that the terminology is more accurate. And secondly, it takes away this kind of almost control word. Like, I feel like custody is a word that symbolizes control. I've got custody. And, when you're dealing with people who are already in a conflict and, perhaps in a more acrimonious situation, I just think that's terminology. It's a fighting word, and so it just throws more things out there to fight about, whereas decision making is really what it is. And I think it's easier for people to understand that, oh yeah, we should share decision making on those important things. That makes sense.
For years there has been this ongoing debate whether there should be a presumption of shared custody, and it's been fought about in the courts, it's been fought about in legislatures, it's been fought about in social science circles, and the law never passed. And the law remains that the determination of where the children should live and how much time they should spend with each parent continues to be the best interests test, which means that it's based on what is best for that child. And even within one family, there could be different best interests per child in the family. But on the subject of what you just said, the ongoing debate, here's my question to you is, do you see that the language change will reduce litigation or post-separation conflict between parents who are in a contest over the rights of a child?
I mean, I think that's a really interesting question. I'd like to say yes, that I think it will, because I think that it is more positive terminology, and I think the positive psychological effects of it are good. I mean, I guess it remains to be seen whether it actually will. I'm not sure where I stand on that, because I as I say, I hope that it will, but at the end of the day, I'm not so sure that just the terminology will really end up reducing conflict between people who are already in high conflict. But I think it's going to give people a better understanding to begin with of what the terminology means, rather than this misunderstanding about the word custody and what it is. So from that standpoint, maybe there's some hope that it will reduce reduce litigation on that issue, and people having had a better understanding of what the words actually mean will be less apt to fight about it. I'm
going to actually make a controversial comment.
Okay. It wouldn't be the first time, Steve.
Sure enough. The idea behind the child support guidelines, by creating tables that said, if you earn this money, this is how much you have to pay. The whole idea behind that law change, which is now 20 plus years ago, was to reduce conflict. Because in cases prior to the child support guidelines, federally and provincially, people would come to court, and on any random day, you'd get a random judge, and that random judge would grant any random number of child support based on what the judge believed was the right amount. So the child support guidelines came out, and in the preamble, section 1 of the child support guidelines says The purpose of this law is to reduce conflict and make child support predictable. I'm using that as a launching pad for the comment about this new legislation. For many, many years, and I'll tell you even a funny story in a second, people would fight over custody. No, I want it. No, I want it. No, I want it. No, I want it. And then we had new adjectives to add to the word custody. Well, hold on a second. What kind of custody do you want? Do you want sole custody? Do you want shared custody? Do you want split custody? Do you want joint custody? So there's all these new words of custody. Well, hold on a second. You know, we've got 3 children. 2 live with me. 1 lives with you. So that's split custody. Well, what about, I want the kids to be with me equal to you. So that's shared custody. What about joint custody? Does joint custody mean equal time? No, it means equal decision-making power. So there was all these other fights by adding the word in front of the word custody. And that led to, and here's my funny story, for the first 10, 15 years of my law practice, I used to do the equivalent of emergency room family law. What does that mean? I was duty counsel in the courts. People would show up to court on any random day. They didn't have a lawyer. I was there to assist them. We and a whole cadre of other family law lawyers who were on the legal aid roster, and we were there for the day to serve as the equivalent of an ER doctor to these people that didn't have a lawyer. Within that population, there was a subset of people that young people, generally between ages 18 to like 25, that were on social assistance. And when social assistance was being paid to, say, a young mom, oftentimes the social assistance worker would commence the application for child support and for custody from the father of the child, which, by the way, back then, and I'm not sure if it's politically correct or not, they would call it the baby father or the baby mother. Fine. So I would then serve as the lawyer for the 19, 20, 21-year-old guy that showed up who was served just a couple weeks ago with an application for custody of the child and for child support. And in a lot of these cases, it was unplanned. It was not a planned pregnancy. The mother decided to have the child, and the father, in a lot of these cases, had no relationship with the child. And I'm not even talking about a 3-month-old. I'm talking about like a 3-year-old or a 5-year-old or a 6-year-old. No relationship. But they would be served with the court documents, and they'd show up to court, and we would say the mom wants custody. And invariably, the father would say, oh no, I want joint custody. You don't even have a relationship with a kid. You want joint custody of a child you don't even know? Anyway, that's a side note. But the point I'm trying to make is the word custody actually reduced the conflict. Why? Because it was black and white. You either had custody or you didn't have custody. And if the mom had custody or the father, that person had the child live with them. That person made all the decisions regarding the child. It was done. The order was made. So-and-so had custody. We were done. So now we're into this new paradigm. We've got parenting. What does that even mean? Who's doing the parenting? Who's doing more of the parenting? Who's doing less of the parenting? Then you've got this concept called contact. Okay, what? We replaced the word access with contact? Does that really reduce the conflict? Like, really, you could have called it anything. And now you've got this whole new law that says, hey, judge, every judge dealing with parenting must decide who's in charge of the decision making. Whereas before, when a judge granted so-and-so custody, it was a done deal. So now every case, there's going to be a debate. Well, hold on a second. If she gets to decide which school the kids go to, then shouldn't I be able to decide their medical care? And if she decides that they're going to be raised Catholic, shouldn't I be able to decide who their doctors and dentists are? So I'm putting out to you that this change in law, which was supposed to reduce conflict, might actually raise the conflict. And let me ask you one question, Leanne, on this. Are fathers in 2021 more or less involved in their children's lives than 30 years ago when the word custody was used?
Oh, they're far more involved. You know, fathers today are, right from a young age, are far more involved with their children than ever, you know? So, which
so
is,
when
I
they
think,
split up, what's going to happen?
Well, they're gonna argue because, you know, I find what often happens is the mom comes and the mom is usually the one who wants custody, and wants more parenting time and wants dad to have the old model of Wednesday nights and every second weekend. And dad wants the children half the time and wants, shared decision making and, all of these things. And so there's more arguing. But, nowadays, the way the courts are deciding, it's recognizing that dads are far more involved. And so these old school models and schedules and things like that are not appropriate here in 2021. I just want to flip it now onto the other part of the changes to the legislation, which is with respect, the big change, there's multiple changes, but another big change is with respect to domestic violence and its recognition, is being a factor to be taken into account in determining the best interests of children. Previously, although in cases there, judges may have noted that and taken it into account on some level, there was no formal recognition of it that they had to, or in terms of the legislation. And I, as somebody who's done a lot of work with victims of domestic violence, I see that as a very positive development, and I see it very positive that they're not only discussing physical violence, but it goes further to include psychological abuse, financial abuse, harassment, sexual abuse, all of those sorts of things. Any, sort of a pattern of what's the word they use? I think power, coercion, and controlling behavior, which is really good. So I'm interested to hear your thoughts on that as well, Steve.
So, it's funny. We have really peeled the layers of the onion on coercive control, spousal abuse, partner violence. We think that abuse means hand on body. That is the most obvious, easy, simplistic way of looking at it. Most of the abuse, and like you, I have a history representing victims of abuse. For many years, I was doing a lot of work for women who were coming out of women's shelters. They were referring them to me so that I could actually ensure their safety and security and that of their children. We would create escape plans. We would create plans in order to establish and settle these victims in residences where the father or ex-husband, ex-partner didn't know about it. Oftentimes the victim was a woman. So I'm trying to be as politically correct about this as possible. But the point is, the actual greatest scarring is not the physical act. It is the psychological, the emotional, the verbal. I would see these women who were so badly beaten down with words that were thrown at them for 5, 10, 20 years, belittling them, making them feel so small that when they exited the relationship, they had no self-esteem, they had no independence, they were unable to carry their lives on their own. It almost became to the point where they were paralyzed from years of non-physical abuse. And so I am thankful to the governments of Canada and the government of Ontario to pass the legislation that includes the definition of what abuse is, to include what you just said, Leanne, which is far more than the physical side of it. And if you look closely at the new legislation, it even includes harassment, which includes stalking, which once, and as I said to you guys about 10 minutes ago, once the judges get hold of this and start interpreting the words abuse or harassment, this will include what we are already experiencing, where some people are using social media to hurt their ex-spouses by posting pictures and videos and descriptions of their exes in such a way that demonizes them, pathologizes them, and makes them look and feel small. And that is going to be the next chapter of how judges are interpreting this. And so we don't lose the context. How does that connect with parenting? Answer: if someone is going to behave that way to the other parent, can we trust them as a parent to have the children? And what are they going to do? What messages are they going to give? What images are they going to insert in the minds of these impressionable young children if this is what they're doing, posting things about somebody else online?
Oh, exactly. And I mean, research has shown time and time again that children who grow up in homes where there's any type of abuse, that it affects them very negatively. That often, you know, if it's dad abusing mom, whether again it's emotional abuse, verbal abuse, physical abuse, you know, financial abuse, but the children are aware of far more than we realize. And when it's a situation where, say, dad is the one abusing mom, the girls who grow up in that environment tend to seek out relationships as they grow older where they are treated the same way, and they seek out abusive relationships where they are abused. And boys who grow up in that home grow up to be abusers themselves, because that's how they're taught that men treat women. So
That's
the
right.
impact on children of growing up in an environment where there's any type of abuse is significant. And, you know, that's something I've often said to women who are in those situations. And I want to be politically correct because there are men who are abused too. But I say, like, if I can appeal to them to think of their own welfare, I appeal to them to think of the welfare to their children. So I think it is fantastic that the courts are now going to be taking more notice of this, because the legislation is impelling them to do so, or compelling them to do so. Because, you know, I think the criminal law maybe needs to catch up. I mean, the problem is that in criminal law, only physical abuse, you know, threatening death is a criminal offense, but generally, you know, emotional abuse or financial abuse or psychological abuse are not recognized as criminal offenses. And so sometimes in family law, I think that can handicap things too, because if someone wasn't charged with something, you know, well, then is it abuse? And whereas now that it's specifically, you know, there's a list of items that's not there could be other items, it's not all encompassing, but there's this, you know, specific examples of things that are considered to be abuse. So there's now, you know, a great recognition of that. And I was so happy to see financial abuse included on that list, because as you and I both know, Steve, that can be a big problem with a lot of victims too, where the other party's controlling the purse strings, and they come out of a relationship and they have nothing, and they can't even afford a lawyer at times, but their spouse, you know, may have millions of dollars. So it's a real problem. And so I'm glad that they recognize that as a factor as well.
I'm going to pivot because we have a few minutes left, because we covered the change in the language from custody and access to parenting, from access to contact, from custodial decision-making to parental decision-making. We covered the subject of domestic violence and abuse, which is far more than the physical part of it. The non-physical can be far more scarring and detrimental than that. The third thing I want to mention, and there's way more. I mean, if you just look at the table of contents to the changes to the legislation, the table of contents alone is about 10 pages. But the other thing I want to mention before we wrap up is relocation. Relocation in 2021 is a very different word than relocation 20 years, 30 years ago. The reason for that is we are living in an extremely mobile society. As a result of COVID, we have seen people run their businesses from the other side of the world, where they used to run it in one place. We have seen people no longer go into the office, and therefore once the office is gone, you no longer need to be gripped by a residential address near your physical office. And so when it comes to breakup, you have a lot of people saying, you know what? I no longer need to live here. I want to be closer to my parents. I want to be closer to my sister or my brother, or I want to live in a warmer climate. And so splitting up oftentimes is a milestone in people's lives that cause them to take inventory of what they want to do with the next chapter of their life, which may mean that they no longer want to live in the same city as their ex. And when that happens and they have children, they want to relocate. Some people don't use the word relocate. Some people say move back to where I was, because some people marry people from other parts of the world and then they break up and then they want to go back to where they started, which makes total sense. So what does this new legislation say about relocation? It raises limitations. The person that wants to relocate must now give notice, and which would invariably lead to a court hearing, which will invariably take many weeks, months, if not years. And by then, there's going to be a status quo. So I'm going to ask you, how does the status quo factor into the remedy of relocation?
Well, when there's a status quo, it's harder to relocate, quite frankly, because, again, we're always looking at the best interests of the children. And if the children, if a status quo has been established and children are living in a certain location and they're going to school there and they have friends there, to move them to another location, there has to be obviously a greater benefit to their welfare for the move. So, and it's very hard in courts, it's very hard to change a status quo that's been in place. And the longer it's in place, the more challenging it is to change it. So if something is being litigated and it has to go through the system and it's taking a long time, and as we know right now, especially during this period with COVID, the courts are really backlogged and there's no quick access to justice. So a status quo could long be in place, and then it'll be much harder to relocate or get a court.
And when you think about the actual mechanics and the journey, so I'll give you a perfect example. So husband meets wife online. Shockingly, these days, people meet online.
Imagine that.
One lives in one city, the other one lives in another city or another country. They date online, they then meet, they then decide to be exclusive. That then leads to a proposal. That then leads to marriage. Sometimes that leads to immigration applications. One moves to another one's city. It's a very common event. Someone from London, England might move to Toronto. Someone from Toronto might move to Rio de Janeiro. I mean, in the world of working from home on your computer, this has been made so much easier. So you don't even have to give up your job. You could actually say, I'm moving in with my fiance in another city. They start living together for the first time in a new city. One person's away from all of their people, all of their family and friends. Pregnancy occurs. There's a newlywed period. The baby is born. There's conflict. The conflict is difficult. They break up. Let's pretend this breakup occurs in Toronto. Let's pretend that the father is from London, England. So the father says, you know what? I moved here for you. You haven't held your side of the bargain. You've been doing this. You've been doing that. You committed adultery. Maybe, promises that you made weren't kept. Whatever the circumstances are, I want to move back with our newborn to England, where my parents and my sisters and my brothers are. He gives notice to her that he wants to relocate with the child to England. She says, absolutely not. He then commences an application in court. So my question to you, Leanne, is what's next? What's going to happen? And what's the likelihood that this guy's going to be able to move with the kid back to England?
Well, if someone with that situation came through my office door asking me their advice or asking me my advice, I would say that it's probably very unlikely that he's going to be able to do that. You've had a child here in Canada, and mother is here in Canada, and she's opposing the move. If you get consent, it's a much easier process. But the cases we generally see are obviously because someone's not consenting, and by the time an application is commenced and it goes through the various stages of the court process, case conferences and settlement conferences and trial management conferences, and goes to trial, and maybe there's motions in between all of that. I mean, we're looking at possibly years before a decision is rendered. And
but what about his argument that she was adulterous?
That's not going to help him at all. What
if he's a better father? What if, by all accounts, he's just that much more committed?
Well, I mean, if he can show that she's negligent or abusive, that might be a different situation. If that's going to affect, decisions with respect to parenting, because she's a bad parent in terms of being negligent or abusive, and not just you know, she takes them to McDonald's, you know, more times a week than he thinks that she should be doing. If it's truly an issue with respect to her parenting, then he may have a better argument. But he's going to have to establish that, and it can't just, you know, I think him just saying it as well isn't going to be enough. He's going to need corroborating proof of some sort, you know, whether...
And notice I actually said the guy moved from England to Toronto. Let's reverse the genders. Is your answer any different? Mom moved here to be with dad. Dad's family is here. Mom's family is in England. Baby's 2 months old. Different rules?
I would say no. I think in the past, years ago, there would have been different rules because I think that the courts viewed, you know, children should be with their mothers more, especially when they're at such a young age. But the courts have been changing. And I had a case recently where the mom... dad had a 10-month-old and they separated, and mom wanted to move to a different city within Ontario with the 10-month-old baby who was still nursing. Right. And the judge ruled that she had to bring the baby back to Toronto, and that dad was entitled to overnights with the baby, even though the baby was still nursing. And she was just mortified and beside herself. And as a mother who nursed 2 children, I got it. I would have hated to have been in that situation myself, but it was, the judge made it very clear that you know, that the research shows that fathers who are involved from birth, that bonding with them is just as important. And she said she could pump milk, breast milk, and that he should be able to have those overnight. So I don't think the answer is going to be any different whether it's the mother or the father who wants to return to England. I'm curious if you've had any different experiences with any of your clients, Steve. I
think Martha McCarthy, a very senior family law lawyer in town, years ago did a lengthy research study on how judges have ruled on relocation, and it was found that it was close to 50-50. Half of the judges were allowing people to move and half of the judges were not. In other words, it's not predictable. It's people, what is likely to occur.
Yeah, that's interesting.
It's you know, it's a tough topic. It's one of those ethical dilemmas. In the years, we've had ethical dilemmas on, you know, so many different legal topics over the years. You know, Sunday shopping, the right of a woman to control her body through having a choice to abort or not. You know, same-sex relationships being recognized under law. And in family law, we have, can the mom not move back to England with her child? Can the father not move back to his family with the child? I mean, these are tough cases, and that's why I'm proud to say I'm a Canadian lawyer where we, you know, it's not black and white. Each case is looked at on its own 2 legs and decided in the most fairest way possible.
Yeah, I agree.
So it's a pleasure speaking with you. We have so much more to say on this, but we'll have to do this another time.
Yeah, so good to see you, and we'll see you next week, hopefully.
You got it. Be well again. Take care.
Thanks for tuning in, everyone. Bye.
Bye-bye.